Good evening, everyone. I'm Professor Michelle Foster, the Dean of Melbourne Law School, and it is such a pleasure to welcome you to the 2025 Kenneth Bailey Memorial Lecture. I'd like to begin by acknowledging that we are gathering this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to elders past, present and emerging, and extend that respect to all Indigenous people who are with us this evening. I'd also like to acknowledge that it's an historic week in the state of Victoria with the introduction of the statewide treaty bill into the Victorian Parliament yesterday. Well, this lecture series honours the fourth Dean of our law school, Sir Kenneth Bailey. Bailey was Dean of the Melbourne Law School from 1928 to 1936 and then again from 1938 to 1942. He was then appointed Commonwealth Solicitor General in 1946, a position he held with great distinction until 1964. Sir Kenneth Bailey made significant contributions to the establishment of the United Nations and the drafting of the Statute of the International Court of Justice at the San Francisco Conference in 1945. He was instrumental in cementing Australia's early partnership with the United Nations, and he became a trusted leader of Australian delegations to UN conferences during the body's first decades. He was committed to Australia's participation in international affairs, and his vision of the role Australia could play in advancing international cooperation during the 20th century was significant. Well, Melbourne Law School is delighted to co-host this lecture series with the Melbourne Journal of International Law. The Melbourne Journal of International Law is the preeminent international law journal in the Southeast Asian region, published twice annually. And the journal is managed by a very competent editorial board of MLS students. I'm very grateful to the journal's editors for their stewardship of this really important initiative, and I'm really pleased to welcome some of the editors tonight, and in particular Jacinta Spear, who will offer a vote of thanks to close our evening. But now I'm delighted to welcome my colleague Professor Margaret Young, who's the Director of the Institute for International Law and the Humanities here at Melbourne Law School. He was going to introduce our very distinguished speaker and will also moderate the Q&A at the end of the lecture. I'd just like to remind you that tonight's event is being recorded and will be available on the website before too long. But now it's my great pleasure to hand over to Margaret, who is going to introduce our distinguished speaker, and I wish you all a lovely evening. Thank you so much for being here.
Thank you, Dean Foster. Your Excellency, distinguished guests, members of the profession, university colleagues and students, and a special welcome to First Nations people joining us, including from the Wurundjeri peoples of the Kulin Nation, on whose land the Melbourne Law School stands. It's a great pleasure for me to introduce our speaker for tonight's event. Her Excellency, Dr Eselealofa Apinelu, is High Commissioner of Tuvalu to Fiji and Secretary-General of the Commission of Small Island States on Climate Change and International Law. These are two highly significant roles in the present moment of renewed legal certainty about climate obligations, Pacific resilience and international law, and connect strongly with Sir Kenneth Bailey's legacy. In addition to these distinguished roles, Dr Apinelu has a long association with Melbourne Law School. She's been involved in our constitutional transformation network convened by Laureate Professor Emeritus Cheryl Saunders, who I am delighted to acknowledge in the audience tonight, along with our colleague in the network, Professor Tom Daly. She also wrote the entry for Tuvalu in the 2023 report on climate change and democracy, Insights from Asia and the Pacific, led by Professor Ju Chong Tam. She holds a PhD from Swinburne University of Technology, and her thesis was evocatively titled Standing Under Whenua, Customary Rights and Human Rights in Post-Colonial Tuvalu. Dr Apinelu also holds qualifications from the Australian National University, the University of Tasmania and the University of the South Pacific. I first met Dr Apinelu when she provided magnetic regional leadership at a conference on the law of the sea in Timor-Leste, and was absolutely delighted when she accepted our invitation to present tonight's memorial lecture in honour of Sir Kenneth Bailey. With her commitment to cooperation between states, and institution building, Dr. Apinelu carries the spirit of Sir Kenneth. This is apparent in her work with bodies such as the highly innovative COSIS, which Tuvalu founded in 2021 with Antigua and Barbados, in anticipation of initiating a request for an advisory opinion on climate obligations from the International Tribunal for the Law of the Sea in Hamburg, seeking legal certainty about whether greenhouse gas emissions constituted pollution under the United Nations Convention on the Law of the Sea. And you'll soon hear what the tribunal ruled. Like Sir Kenneth, Dr. Apinelu has also appeared before the International Court of Justice in The Hague, when in December last year she represented COSIS during those memorable oral proceedings which led to this year's groundbreaking advisory opinion on climate obligations delivered on 23rd of July. As we will hear, the advisory opinion has ruled that there are binding legal obligations on all states to address climate change, stemming from treaty and customary international law, and that a breach of these obligations is an internationally wrongful act that may give rise to duties to provide compensation and restitution to specially affected states. COSIS's advocacy about sea level rise and increasing precarity for small island states resonated strongly with the court in reaching its views. Indeed, evidence of vulnerability from Tuvalu was repeated in the separate opinion of Judge Hilary Charlesworth when referencing the groups particularly affected by the adverse impacts of climate change. From my own perspective, as one of the pro bono legal counsel for the International Union for the Conservation of Nature in the case, I was especially grateful to the leadership of Pacific nations in getting us to this crucial point in international law, including in recognising the link between climate, biodiversity and human rights protections. We will hear Dr. Apinelu's reflections about the advisory proceedings over the next 40 minutes or so, followed by a short period of Q&A and a vote of thanks from Jacinta Spear on behalf of the editors of the Melbourne Journal of International Law. So thank you, Essie, for coming back to the law school, for sharing your experiences and reflections from Hamburg to The Hague. Thank you.
The Dean of the Law School, Foster, Margaret, to all the distinguished participants that are here, ladies and gentlemen, students and members of the public that are here. Let me start by acknowledging the traditional owners of the land on which we gather this evening, and I pay my respect to their elders, past, present, and incoming. Thank you indeed for joining me at the law school this evening. And thank you, too, for the invitation to be able to deliver this in this lecture series. Sir Kenneth Bailey, as has been introduced, has played a significant part in Australia's contribution to the United Nations international law. United Nations and international law is a body whose leadership relevance is being questioned for various reasons, but a body that nonetheless still holds hope for many of us. I was also intrigued reading on Bailey's life to see the similarities in career paths that we took as individuals. Before taking up my role as High Commissioner for Tuvalu in Fiji, like Bailey, I was a principal legal advisor for the government, the parliament, and the various government bodies in Tuvalu. In that role, I was constantly exposed to the challenges that we in Tuvalu face as Indigenous with regards to disconnection between our way of understanding the life that we have and the laws that encompass and talk about the life that we have as Indigenous Tuvaluans. I mention this in the forefront of my talk because from my observation, the same disconnection plays the same role in international forum. There is a great misunderstanding of the real impacts of climate change on small island states like Tuvalu. So when I was invited to be part of this memorial lecture series and to speak to the development of international law, I thank God. I thank God for the opportunity to provide us with the opportunity to continue to share from small island states our voices and our understanding and our hopes that sometime, somewhere, we as human beings can address the disconnection in our understandings and hopefully make this world a better place that we can all enjoy. A place that for us, from small island state, can give hope for our future generation. Accordingly, I am greatly honored to be delivering this lecture and to join the eminent speakers that have presented on this series before me. I have chosen this title, From Hamburg to Hague, Climate Change, Advisory Opinions, and the call of small island states to speak to this evening for some specific reasons. First, I wanted to know whether international law in the United Nations system is still relevant in this point in time, given all the challenges that we are having. And that concern too was raised by a friend of mine when I was asked what I'm doing here in Melbourne and what am I going to talk about. When I mentioned the the advisory opinions and the UN system, I was asked exactly the same thing. Is it still relevant? Do we need to talk about those? We see what's happening in the world. So I think it provides an opportunity in this series for me to share some reflections on that. And secondly, I also wanted to see whether advisory opinions will be the new norm in climate diplomacy. And then I will share my personal reflections of the journey from Hamburg to The Hague. So what's in Hamburg? For us from Tuvalu, I think our seafarers know this Hamburg like they know our islands in the Pacific. They travel there a lot. But in Hamburg, I went there in my capacity as the Secretary General for the Commission of Small Island States on Climate Change and International Law. But it was also in Hamburg that I met a Tuvaluan seafarer who has made Germany his home, that made the visit to this court more bearable. So COSIS, what is it? What is COSIS? It is an intergovernmental organization with international legal personality. As explained, it was established by Antigua and Barbuda and Tuvalu on the 31st of October in 2021 in Edinburgh, at the same time that the Conference of the Parties were meeting, the 26th meeting of the UNFCCC in Glasgow. The Commission is represented by its co-chairs, which at the moment are the two founding nations, Antigua and Barbuda and Tuvalu. Membership is open to all members of small island states, the IOSIS. The current members of COSIS include Antigua and Barbuda, Tuvalu, Palau, Niue, the Republic of Vanuatu, St. Lucia, St. Vincent and the Grenadines, St. Christopher, St. Kitts and Nevis, and the Bahamas. So when I discuss COSIS, I am carrying with COSIS all these member countries. The COSIS agreement authorizes the Commission to represent the interests of its members in international forums and courts. It further authorizes the Commission to appoint legal experts, and 14 international lawyers have been appointed of a gender-balanced mix to make up the Committee of Legal Experts for COSIS. The preamble provisions for the agreement establishing COSIS expresses the determination of its members, and it states that it must take immediate action to protect and preserve the climate system and the marine environment based on equity and the common but differentiated responsibilities of states to combat climate change. So on the 12th of December 2022, barely a year after COSIS was formed, it initiated proceedings before the International Tribunal for Law of the Sea, the ITLOS, which sits at Hamburg. And that was why we went to Hamburg. COSIS asked the court for court's assistance in interpreting specific issues on what the state obligations are to prevent, reduce, and control pollution of the marine environment, and what are the obligations of the states to protect and preserve the environment, in both within the context of climate change. Before I discuss the outcome of the advisory opinion, we'd also like to share how COSIS came about, and that it goes to show the role the small island countries play. COSIS came about when I was still in Tuvalu as the Attorney General of Tuvalu. This was during COVID, and we thank COVID for bringing an increasing amount of communications, virtual communications. That opportunity got the time to, I received a call from a colleague of mine that we went to law school together in Tasmania, and introduced the idea whether we will be interested in taking up this option. I was introduced to more lawyers that are working on this area, in particular Payam, Akavan, and David Freestone. We had discussions with Pio, the later other colleagues who are no longer with us, but who were determined to have this materialize. After listening to what was presented and from the expert international lawyers, I found it odd that something as simple as getting two countries to agree and utilize the existing legal mechanisms that are out there hasn't been utilized. So I thought, yes, why not? I don't want to reflect back in how many years' time, and my country and my kids will say, Mom, you were there. Why didn't you accept the opportunity to take this opinion? Take the opportunity to make sure that we get the assistance from systems that were set up to assist us. And on that note, it was presented to the government, and the government of in Tuvalu, I thank them that they also have believed in the idea, and COSIS was born. So with COSIS, the rest now is history. They managed to bring the case before the International Tribunal, the Law of the Sea, and it's the first case that asks the tribunal to provide us an opinion to help us understand the international system, especially UNCLOS, which it is a UN-made agreement. For the first time ever, a tribunal managed to unanimously provide an opinion on how and what UNCLOS brings to the table with its members, non-members, the responsibilities. To summarize the key takeaways from this opinion, the ITLOS 21 judges unanimously agreed that UNCLOS, or the United Nations Convention on Law of the Sea, imposes robust obligations on its 169 member parties to mitigate climate change and assist developing states in adapting to its effects. Of particular interest for small island states and Tuvalu, the tribunal also placed science as the center of its analysis of the issues brought before the tribunal. It found that the best available plays a crucial role in determining state parties' obligations regarding climate change. The best available science, the court also found, includes the reports of the Intergovernmental Panel on Climate Change, the IPCC, was held as the authoritative assessments of scientific knowledge on climate change. The tribunal, further relying on the IPCC report, noted that human activities, principally through the greenhouse gas emissions, have unequivocally caused climate change. Climate change caused by our own human-made. The tribunal further acknowledged the critical role that the ocean plays in the climate system and its devastating effect on small island states, which are amongst the most vulnerable. The tribunal also upheld the need to maintain or to curtail rises in temperatures within the 1.5 degrees pre-industrial level. On the relevance of the Paris Agreement and the relationship between UNCLOS and Paris Agreement, that both are relevant for the assessment of necessary measures, but importantly, between the two, what I find important of what the court delivered is that both the Paris Agreement and UNCLOS are complementary to each other, and that one doesn't displace the other. The tribunal further acknowledged that UNCLOS requires state parties to act with diligence to prevent, reduce, control marine pollution through greenhouse gas emissions. Tribunal, I'm sharing these specific findings from the advisory opinion as they become relevant when we refer to the rulings of the International Court of Justice from the Hague that I will refer to later. The tribunal also confirmed that states' due diligence obligations require them to regulate the conduct of private parties under their jurisdiction or control. Interestingly for us, they also found that states with greater means and capabilities must do more to reduce such emissions than states with less means and capabilities. On adaptation, ITLOS found that UNCLOS requires developed state parties to assist developing state parties in their efforts to adapt to climate change. The opinion of the tribunal is a very welcoming opinion for small island states. At the time when ITLOS delivered its opinion, most countries, Tuvalu and small island countries included, we were awaiting the processes before the International Court of Justice on the Vanuatu-led initiative, which was an initiative brought by South Pacific Island students fighting climate change at the law school at the University of the South Pacific in Vanuatu. At that time, certain deadlines had been given to member countries to provide their written submissions. But when the ITLOS opinion was delivered, the time was extended. that small gesture from the International Court of Justice for me, as a person and from the Pacific, I was already happy when I heard that the extension has been given. Because even without explanation, I think at that moment in time, see that the courts, they are human after all, and that they have made use of the good opportunity to allow member states and those that are interested to utilize the advisory opinion that has just been released by the ITLOS in their presentations before the ICJ. So COSIS, Tuvalu, and most small islands, they took the opportunity to revise their submissions. And we are also thankful for all the regional organizations and the various lawyers, NGOs that all helped from our region to make sure that our submissions are ready for the International Court of Justice to consider. So on the 23rd of July 2025, this year, just a couple of months ago, the ICJ delivered its advisory opinion on this Vanuatu letter request, which concerned obligations of states under international law to protect and preserve the climate system and other parts of the environment for the present and future generations, and the legal consequences of such obligations. The ICJ opinion is new. Most of us are still reading and trying to digest, analyze the whole opinion. But a few takeaways I would like to share that are important for our small island countries. And that in analyzing the legal instruments that are relevant for international law and the most direct relevant applicable law in the proceedings, the court concluded that the three climate change treaties, the UNFCCC, the Kyoto Protocol, the Paris Agreement, as well as other environmental treaties, namely UNCLOS, the ozone layer treaties, Biodiversity Convention, and the Certification Convention, they all form part of the most directly relevant applicable law. Where it concerns UNCLOS, it draws heavily on the opinion that was provided by the tribunal. The court also concluded that certain customary international obligations form part of this. This includes the duty to prevent significant harm to the environment and the duty to cooperate for the protection of the environment. It also reflected on ITLOS advisory opinion where it articulates the harm and prevention and due diligence. Interestingly, but I think for good cause, the court also noted that certain international principles are applicable as guiding principles for the interpretation and the application of the most direct relevant rules. The court, however, these principles include like sustainable development, common but differentiated responsibilities and respective capabilities, equity, intergenerational equity, and the precautionary principle. However, I think the court was very clear in rejecting the inclusion of polluter pays principle. It's some matter for discussion. But the court also unanimously agreed to the science that was already shared in the ITLOS opinion. And that's the need to respect the call for the 1.5 degrees Celsius. As the threshold of the agreed temperature goal under the Paris Agreement. Importantly, the court also shared the opinion that all states, not just those that are parties to the agreement, they must cooperate to protect the climate, including towards the 1.5 degrees collective temperature goal. On what's most interesting to me as a Tuvaluan and as a from small island states is their finding on sea level rise and sovereignty. The court noted the sea level rise is a serious threat, especially for small island and low-lying coastal states, with the potential consequences for territorial integrity of states, their permanent sovereignty over natural resources, and the right to self-determination. The court supported the idea that sea level rise causes the coast of small island states and low-lying coastal states to recede, thereby potentially affecting the outer limits of the maritime zones or even threatening their very existence. And from that, the court made very important and interesting observations from where we come from. The first observation was that the court concluded that UNCLOS does not require state parties to update their maritime baselines due to physical coastal changes resulting from climate change-related sea level rise. This is a very welcoming opinion for us from the Pacific that have already also been pushing for declarations to recognize this very opinion that the court is sharing. And second, the court finds that the disappearance of one of the constituent elements of statehood, that is, if the complete loss of a state's territory as a result of sea level rise, does not necessarily entail a loss of statehood. And third, the court concludes that the states have duties to cooperate to address the impacts of sea level rise. So as small island states, what do we take from these advisory opinions? I believe the opinions are still in their infancy as far as people from the islands are concerned. Lawyers may have read it, some may have read the opinions. The majority of the people haven't read these opinions. Even if they haven't read, they haven't really encompassed what these opinions are about, and we are still trying to understand the nuances that may be included in these opinions. But one thing that we know for sure from where we come from, in the islands, small island states, what this opinion is speaking to is what the small island states, including Tuvalu, have been advocating for years. That climate change is real and it's affecting us. And climate change is from our own man-made. It wasn't something that just happened. It is us. It's our making that has caused climate change. And this is what the opinions are saying. For with or without the science, we in Tuvalu, I believe, are living testament to the impact, the devastating impact of climate change. Where the science is making predictions for the next 25, 50, 100 years of how devastating the world would be, and especially for people from small island states, if we cannot keep temperature rise below the 1.5 degrees, the result will be devastating for small island states. But we in Tuvalu and small island states are already living this reality. The science for Tuvalu is threatening, and we do not want to believe it, but the science don't lie. Failure to halt global temperature rise within the 1.5 degrees pre-industrial level spells disaster for our countries. In terms of sea level rise and the current rate of sea level rise, For Tuvalu, the next 25 years, which puts us at 2050, more than 50% of Tuvalu's land territory would be regularly flooded by regular tidal surges. Just regular tidal surges. In 50 years' time, that's 2100, more than 90% of Tuvalu's land territory would suffer the same fate. 2100, 90% of Tuvalu will be flooded regularly by just regular tidal surges. We are not even talking about storms. So for the small island countries like Tuvalu, the year 2100 seemed to have already surpassed us. It's like we have traveled in a time warp and we are already living in the future. There is constant flooding. We have cyclones, there's increasing health challenges, there's loss of islands, and the list goes on. We as governments and supporters like to remind our people to try and live healthy lives. As we live healthy lives, we can minimize or reduce our health challenges, health issues, health budget. But what type of healthy lifestyle is that for Tuvaluan? To a Tuvaluan person whose lived reality is life on land that is already infiltrated by salt water, land that is constantly affected by sea level rise and erosion, land that is more expensive to cultivate for domestic consumption than relying on foreign imports, land that even if it is improved, as is our current reclamations and adaptation works are addressing, will take years to be ready for any meaningful farming. It is not easy for a Tuvaluan family to try and live a healthy lifestyle in Tuvalu, not in our current climate-affected conditions. For some, I think for most, it would simply be easier to just pack up and leave. But where would they go? That is another challenge, and that's another discussion. But the impacts of climate change are real for Tuvalu, living in Tuvalu. But we are not giving up, and the government is doing all that it can to make sure that Tuvalu, the land and the people, will continue to thrive in challenging circumstances. So what is Tuvalu doing at the moment? Nationally, it's doing its coastal adaptation program, whose main objective is to enhance the resilience and adaptability of the coastlines of Tuvalu, and also to reclaim much needed land for development. Tuvalu is also, together with small island states, helping develop international law. This is through our joint communiques with other nations, as well as declarations through the forum. In 2021, the Forum Island countries, 18 member countries, adopted the Declaration on the preserving maritime zones in the face of climate change related sea level rise. It asserts that Pacific Island countries will maintain their maritime zones without reduction, notwithstanding climate change-induced sea level rise, provided their maritime boundaries are duly demarcated in accordance with the UN Law of the Sea and duly registered with the United Nations. Also in 2023, they adopted the Declaration on the Continuity of Statehood and the Protection of Persons in the Face of Climate Change-related sea level rise. It affirms the principle of statehood continuity that members of the Pacific Island Forum claim for their countries despite the impact of climate-induced sea level rise. Both these declarations, we read the advisory opinions, have been well discussed and well supported too by the advisory opinions. These opinions from the Pacific Island countries were also endorsed by the IOCs, and they were also further supported by the members of the Commonwealth. Bilaterally, Tuvalu is also through treaties, and we have our Whalepili Treaty Union with Australia. Then we have Australia help Tuvalu in terms of climate change related disasters. The treaty also committed Tuvalu and Australia under the cooperation scheme to work together to help the citizens of Tuvalu to stay in their homes with safety and dignity. My apologies for that. Here to conclude, I think that twin advisory opinions of the ITLOS and the ICJ are very promising and encouraging for people in small island countries. For Tuvalu in particular, we're happy to see that most of the arguments we put through were considered, made it easier for us now to take each other the way forward. And I hope also for other member countries to utilize the opinions and make use of the opinions. From my personal observations of this journey, I think that the number of interested parties that joined, I think it shows the possibility that advisory opinion may be another viable option for climate discussions going forward. And also interestingly, to note that these two cases are amongst the first cases to be taken to this court. Shows that there is an underutilization of the systems that are already there for us to use, and that we need to make better use of these systems. And how do we make better use of these systems? I think the stories behind the two cases that made their way all the way up to the pinnacle courts of the United Nations system may be helpful. With the ICJ decision, we could see that for both, it doesn't take a nation to start the journey. It only requires dedicated individuals to think beyond the norms, believe, and pursue a dream. Likewise, that was the dream that was taken up by the Pacific Island students fighting climate change, an idea that was born in the confines of their classrooms at university. It was taken up by a member state, and it took us all the way to the Hague. Similarly, the same thing happened with a few dedicated, like-minded people who believed and gave birth to COSIS, the Commission of Small Island States on Climate Change and International Law. It took us to Hamburg. So to the friend who asks if the UN and international law is still relevant, my humble opinion at this point in time, in the absence of any other better system, it may be our best chance at the moment. But with climate change, the devastating impacts of climate change for Tuvalu and small island states, that the science are predicting should be happening in 25, 50, 100 years is happening now. And we are living that reality now. So let's all unite and do our part to save the environment. And let's save Tuvalu to save the world. I thank you very much.
Good evening. My name is Jacinda Spear, and I'm one of the 2025 editors of the Melbourne Journal of International Law, alongside my co-editors Igor Vishnyakov and Puilam Low. On behalf of the journal, we'd like to sincerely thank Her Excellency Dr Apinelu for delivering this year's Sir Kenneth Bailey Memorial Lecture, and Professor Margaret Young and the Institute for International Law and the Humanities for co-hosting this event and continuing to create spaces where these vital conversations can take place. We would also like to thank everyone in attendance today. Dr Apinelu has shown how international law, advisory opinions, and above all, the voices of small island states are reshaping how the world responds to the climate crisis. The journal has been honoured to co-host this lecture since 2016, in part because it aligns significantly with the journal's goal of being a journal dedicated to international law issues in the Asia-Pacific region. This lecture also sits beautifully within the legacy of Sir Kenneth Bailey, whose work helped to build international law as a discipline that connects legal thought with the pressing needs of humanity. Dr Apinelu, thank you for your insight, your generosity, and your leadership. I would like to, on behalf of the journal and the law school, present a small gift as a token of our appreciation. And could we please join in showing our appreciation to Dr Apinelu again?
Thank you. Thank you very much.